Thank you so much for joining me. A federal judge just ordered United States Marshals to take Donald Trump's lawyers into custody. Not a warning, not a fine, custody. Judge Caldwell called the Marshals back into the courtroom after Trump's attorneys continued to defy direct orders. And when those Marshals returned, they weren't there for security. They were there for arrests. This isn't political theater. This isn't posturing. This is a sitting federal judge placing the former president's legal team under physical restraint for contempt of court. When officers of the court get detained by marshals in a federal courtroom, something catastrophic has just happened to someone's legal strategy, and Trump's team just found out the hard way. What happens when you push a federal judge too far? So what triggered this extraordinary moment? It started when Trump's attorneys refused for the third consecutive time to comply with Judge Caldwell's direct order to produce documents the court had demanded weeks ago. But this time, they went further. They challenged the judge's authority in open court, accused her of bias, and stated they would not comply regardless of the consequences. This isn't just another legal skirmish in Trump's endless courtroom battles. This is what happens when lawyers treat a federal courtroom like a campaign rally and discover that judges have actual power. The Constitution gives federal judges the authority to maintain order in their courtrooms. The United States Marshal Service exists in part to enforce that authority. And Judge Caldwell just invoked both. For years, Trump's legal strategy has relied on delay, defiance, and the assumption that consequences would never actually materialize. That assumption just died in a Washington, D.C. courtroom. And I have the court filings, the witness accounts, and the legal analysis right here. Let me show you exactly what happened, why Judge Caldwell reached her breaking point, and what this means for every Trump case moving forward. Here's what happened in that courtroom, the thing that everyone's talking about right now. At approximately 2:47 p.m. Eastern Time, Judge Caldwell issued her final warning. She had ordered Trump's attorneys to produce a specific set of financial documents 3 weeks ago. The deadline had passed. An extension had been granted. That deadline had also passed. And according to court transcripts, the defense had produced nothing. This is what they clicked for. This is the moment. Judge Caldwell reportedly stated from the bench, "Counsel, you have exhausted this court's patience. You have been given every reasonable opportunity to comply. You have chosen defiance. That choice has consequences." Lead attorney Stanley Woodward allegedly responded by questioning whether the court had jurisdiction to compel the documents at all, an argument that had already been rejected twice in prior rulings. According to witnesses present in the courtroom, Judge Caldwell's voice remained steady, but her words landed like a hammer. "Mr. Woodward, you are not in a position to relitigate settled matters. You are in a position to comply with this court's orders. Will you produce the documents?" The answer, according to multiple reports, was no. What happened next stunned everyone in that courtroom. Judge Caldwell called a brief recess. The marshals, who had been positioned near the back of the courtroom, were dismissed. Observers assumed the judge was taking time to consider her options, standard procedure. But 12 minutes later, Judge Caldwell returned to the bench and made a phone call that nobody expected. She ordered the marshals back. When they re-entered the courtroom, Judge Caldwell issued her ruling. The court finds counsel in direct criminal contempt. Marshals, please take the defendants into custody pending a compliance hearing. Not civil contempt, which typically involves fines, criminal contempt, which involves detention. The attorneys were physically escorted from the courtroom, not to a holding cell in the courthouse basement, but to the U.S. Marshals custody facility for processing. But here's the kicker. The contempt order wasn't just about the documents. According to the court filing released within the hour, Judge Caldwell cited a pattern of behavior that included repeated misrepresentations to the court, deliberate delay tactics designed to obstruct proceedings, and public statements calculated to undermine judicial authority. The filing specifically referenced a social media post from one of the attorneys that appeared just hours before the hearing. A post that accused Judge Caldwell of being compromised and predicted she would face consequences for her rulings. Former federal prosecutor Joyce Vance told MSNBC that this was exactly the kind of threat that judges cannot ignore. When you threaten a sitting federal judge on social media and then show up in her courtroom refusing to comply with orders, you're not just risking contempt, you're practically demanding it. Vance stated the contempt order applies to two attorneys, Stanley Woodward and co-counsel Emil Boy. Both were processed by marshals and held pending a compliance hearing scheduled for the following morning. According to sources familiar with the proceedings, bail was initially denied because Judge Caldwell determined the attorneys posed a continuing risk of noncompliance. The court filing includes a remarkable passage that legal experts are already calling unprecedented. Judge Caldwell wrote, "This court does not take this action lightly, but the alternative, allowing officers of the court to openly defy judicial authority without consequence, would render the entire system of justice meaningless." The ruling also notes that the attorneys have 24 hours to purge the contempt by producing the ordered documents. If they comply, they walk free. If they don't, they remain in custody and face formal criminal contempt charges that could result in up to 6 months in federal detention. Hit that subscribe button right now. This story is moving fast, and you won't want to miss a single development. I'm tracking every filing, every hearing, every response as this unfolds. Subscribe so you see exactly what happens next. Now you've seen what happened, but here's how we got here, and it makes this even worse. This confrontation didn't emerge from nothing. It's the culmination of months of escalating defiance that Judge Caldwell had documented in a series of increasingly frustrated rulings. The underlying case involves financial documents related to one of Trump's business entities, documents that prosecutors argue are essential to their case and that Trump's team has fought tooth and nail to keep hidden. The first order for production came in early spring. Trump's attorneys requested an extension. Granted. They requested a second extension citing the need for privilege review. Granted. They then filed a motion challenging the scope of the order. Denied. They filed an interlocutory appeal. Denied. They claimed the documents didn't exist. Prosecutors provided evidence they did. They claimed the documents were protected by executive privilege. The court rejected that argument as inapplicable. Each delay bought Trump's team weeks. But each delay also built a record of what Judge Caldwell would eventually call systematic obstruction. Everything changed on the morning of the hearing when one of Trump's attorneys posted on social media suggesting that Judge Caldwell had been placed in the case to destroy Trump and warning that patriots see what you're doing. According to court filings, Judge Caldwell addressed the post directly from the bench, asking counsel whether they stood by the statement. The response, according to witnesses, was not a retraction. It was an escalation. Sources familiar with the judge's chambers describe her as methodical and deliberate, not someone who makes emotional decisions. She had reportedly spent the previous week preparing for exactly this scenario, researching contempt precedents, and consulting with court security about potential responses. This wasn't a snap decision. This was a carefully considered response to a pattern Judge Caldwell had documented for months. Former federal judge Michael McConnell, a conservative scholar, noted that the Supreme Court has repeatedly upheld judicial contempt powers precisely for situations like this. Courts cannot function if lawyers can simply refuse to comply with orders. The contempt power is the enforcement mechanism that makes the entire system work. What makes this case different from typical contempt situations is the public nature of the defiance. Trump's attorneys weren't quietly failing to meet deadlines. They were loudly proclaiming their refusal and threatening the judge who issued the orders. Judge Caldwell's order specifically addressed this. Contempt in open court accompanied by public threats demands an immediate response. Smash that like button if you're following this. The algorithm uses likes to determine who sees this video, and this story needs to reach as many people as possible. Hit the like right now if you want more people to understand what just happened. The moment that shocked everyone in the courtroom came when the marshals actually approached the defense table. According to witnesses, there was a brief pause, a moment where nobody quite believed what was happening. Stanley Woodward reportedly looked toward the gallery, perhaps expecting someone to intervene. Nobody did. The marshals were professional and calm. They didn't rush. They didn't raise their voices. They simply approached and stated that counsel needed to come with them. Reporters present described the courtroom as completely silent. The only sound was the scratch of courtroom artists' pencils on paper, the sketches that would define this historic moment. Woodward reportedly asked if he could gather his papers. The marshal said yes. He asked if he could make a phone call. The marshal said that would be handled during processing, and then they walked him out, not through the public exit, through the side door that leads to the holding areas. One court observer, a veteran attorney who has practiced before Judge Caldwell for 20 years, told reporters outside, "I've never seen anything like that in my entire career. I didn't think it could happen. I didn't think any lawyer would push a judge that far." The courtroom remained silent for nearly a full minute after the attorneys were removed. Judge Caldwell reportedly took a moment to compose herself, then addressed the remaining parties. This court will now take a 30-minute recess. We will resume with the compliance hearing scheduled for tomorrow morning at 9 and don't go anywhere. There's more to this story and the implications are staggering. Drop a comment right now telling me what you think about this. Should Judge Caldwell have gone even further? Are other judges paying attention? I read every single comment. This isn't the first time attorneys have faced contempt in high-profile cases, but the circumstances here are historically unprecedented. Think back to Watergate. When Nixon's attorneys attempted to defy subpoenas, the courts held firm, but they never had to physically detain counsel. Nixon's team, for all their resistance, ultimately complied before facing arrest. During the Clinton impeachment saga, there were heated moments, accusations of bias, and aggressive legal tactics. But Clinton's lawyers never threatened judges on social media, never publicly proclaimed they would refuse to comply, and never pushed contempt proceedings to the point of custody. Even during the most contentious moments of the Bush v. Gore litigation, attorneys maintained respect for the courts, even while vigorously challenging rulings. What's different now? The normalization of attacking judges. Over the past several years, Trump and his allies have made judicial attacks a standard part of their legal strategy. Judges have been called corrupt, biased, compromised, and worse. In most cases, judges have issued warnings, but stopped short of enforcement. Judge Caldwell just changed that calculus. Constitutional scholar Lawrence Tribe noted that this moment could mark a turning point. For too long, judges have been reluctant to use their contempt powers against powerful defendants who attack them publicly. Judge Caldwell just demonstrated that the power still exists, and judges are willing to use it. The historical parallel that matters most isn't Watergate or Clinton. It's the series of cases in the 1950s and 1960s when Southern officials defied federal court orders on desegregation. In those cases, courts eventually had to use marshals to enforce compliance. Judge Caldwell's order echoes those rulings. Her filing explicitly references the principle that no person, regardless of status or power, stands above the authority of a federal court. The message to other judges is clear: you have this power. The question is whether you're willing to use it. Legal experts are calling this one of the most significant contempt rulings in modern American history. Andrew Weissman, former senior prosecutor on the Miller investigation, told MSNBC that Judge Caldwell's order sends a message that extends far beyond this case. What we're seeing is a federal judge who decided that enough is enough. The pattern of delay, defiance, and intimidation that has characterized Trump's legal strategy has finally met a judge willing to enforce the rules. This changes everything. Weissman emphasized that the criminal contempt designation rather than civil contempt signals that Judge Caldwell views this as more than a procedural dispute. Criminal contempt is about punishment and deterrence. She's not just trying to get documents. She's telling every attorney in America that this behavior has consequences. Meanwhile, George Conway, conservative attorney and frequent Trump critic, offered a stark assessment of what this means for Trump's legal team. These attorneys have been operating under the assumption that rules don't apply to them because they represent Donald Trump. That assumption just got them arrested. Other lawyers watching this will think twice before adopting similar tactics. Former U.S. Attorney Barbara McQuaid added that the detention aspect is particularly significant. Contempt fines are one thing. You can pay a fine and continue defying the court. Detention is different. When marshals escort you to a holding cell, the calculation changes immediately. You're not making social media posts from custody. Even some conservative legal voices have acknowledged the legitimacy of Judge Caldwell's action. Jonathan Turley, who often defends Trump's legal positions, stated that courts must maintain order and that repeated defiance of clear orders leaves judges with few options. Turley added a caveat that this could face appeal, but noted, "The record here is extensive." Judge Caldwell documented months of noncompliance. Appellate courts give significant deference to trial judges on contempt matters. Constitutional law professor Melissa Murray emphasized the broader significance. This is a stress test for the rule of law. If lawyers can threaten judges, refuse court orders, and face no consequences, then courts have no actual power. Judge Caldwell just proved that they do. Former Attorney General Eric Holder called the ruling courageous and added, "Federal judges take an oath to uphold the Constitution. Part of that oath is maintaining the integrity of the judicial process. Judge Caldwell fulfilled that oath today. Do me a favor and hit that like button right now. It genuinely helps this video reach more people. And right now, this story needs to reach everyone who cares about the rule of law. Just slam that like button. It takes 1 second. So what does this actually mean going forward? First, Trump's legal strategy just suffered a catastrophic blow. For years, delay and defiance have been the core tactics. Stretch out proceedings, attack judges, bet that consequences never actually arrive. That bet just lost. Every attorney currently representing Trump or his allies is now recalculating their approach. The contempt order isn't just about Woodward and Bove. It's a signal to every lawyer in every Trump-related case. Judges are watching and they're willing to act. Legal sources suggest several major law firms are already reconsidering their involvement in Trump-related matters. Representation is one thing. Being escorted out of a courtroom in Marshal custody is another. Second, this puts enormous pressure on the appellate courts. Trump's team will certainly appeal the contempt order, likely arguing that Judge Caldwell overreached or that the underlying document orders were improper. But appellate courts historically give wide deference to trial judges on contempt matters, especially when the record is as extensive as this one. If the appeals court upholds Judge Caldwell's ruling, it establishes binding precedent that attorneys can be detained for patterns of defiance, not just single instances of misconduct. That would fundamentally change how every contentious case is litigated. Third, and perhaps most importantly, other judges are watching. Federal courts across the country have faced similar patterns of delay and defiance in Trump-related cases. Judges have issued warnings, imposed minor sanctions, and expressed frustration, but few have gone as far as Judge Caldwell. This ruling gives them cover. If Judge Caldwell's order is upheld, other judges now have clear precedent for using their contempt powers aggressively when attorneys engage in systematic defiance. The implications for democracy are profound. Courts only function if their orders are followed. When powerful defendants can simply refuse to comply, facing no real consequences, the entire system of law becomes optional. Judge Caldwell's order is a statement that the system is not optional. For prosecutors in other Trump cases, this creates both opportunity and complexity. On one hand, judges may be more willing to enforce compliance orders. On the other hand, Trump's team may become more cautious in their defiance, making it harder to trigger similar rulings. For Trump himself, this is a warning shot that landed directly on target. His attorneys are in custody. His legal strategy is in chaos, and the message to any attorney considering representing him is clear. These cases carry personal risk. The next 24 hours are critical. If Woodward and Bove produce the documents, they'll be released and the immediate crisis passes. If they don't, they face formal criminal contempt prosecution and potential sentences of up to 6 months in federal detention. Either way, the precedent is set. Judge Caldwell just proved that federal judges have real power and they're willing to use it. And then Trump made it worse. Within hours of the contempt ruling, Trump posted on Truth Social, calling Judge Caldwell a radical lunatic who was conducting a witch hunt against his great lawyers. He accused the judge of being controlled by the deep state and predicted that real Americans would not stand for this treatment. Instead of addressing the substance of the ruling, the months of non-compliance, the threats, the defiance, Trump went straight to personal attacks. His post included a specific threat. Judges who abuse their power will face consequences when we take back our country. Legal experts immediately pointed out that this post itself could constitute additional contempt or even obstruction of justice. Former prosecutor Renato Mariotti noted, Trump is essentially threatening a sitting federal judge while his attorneys sit in Marshal custody for doing exactly the same thing. This is not a strategy. This is a pattern of behavior that could result in additional sanctions. Trump's campaign team issued a statement calling the contempt order election interference and demanding that Judge Caldwell recuse herself from all Trump-related matters. The statement did not address the specific reasons for the ruling. Conservative media initially struggled to frame the story. Some outlets emphasized the attorney's defiance as a heroic stand against an out-of-control judge. Others quietly acknowledged that refusing court orders and threatening judges is not, in fact, a winning legal strategy. Here's the problem with Trump's response. It validates exactly what Judge Caldwell said. The contempt order specifically cited public statements calculated to undermine judicial authority. Within hours of that ruling, Trump made public statements doing precisely that. He threatened the judge. He attacked the court. He framed Marshal custody as political persecution. Every statement confirms the pattern Judge Caldwell identified. Every attack proves her point. Legal analyst Ellie Honig observed, when your defense to contempt charges is to immediately engage in more contemptible behavior, you've lost the legal argument. You're no longer trying to win in court. You're playing to an audience outside the courtroom. That audience may cheer, but they can't free Woodward and Bowe from Marshal custody. Only compliance can do that. But beyond the immediate legal fallout, this is about something much bigger than Donald Trump. This is about whether courts matter, whether rules apply to everyone, whether power grants immunity. For years, Americans have watched powerful people treat the legal system as optional, delaying, defying, attacking, and assuming that consequences would never actually arrive. That pattern has eroded trust in the fundamental promise of equal justice. Judge Caldwell just restored some of that trust. When she ordered those marshals back into the courtroom, she wasn't just punishing two lawyers. She was demonstrating that the system still works, that judges still have power, that defiance has limits. This affects every American, regardless of political affiliation, because if lawyers for the powerful can simply refuse court orders without consequence, then courts offer no protection for anyone. The rule of law either applies to everyone or it applies to no one. What happened in Judge Caldwell's courtroom is a statement, perhaps the clearest statement in years, that courts will not surrender their authority to those who believe they're above the law. The question now is whether other judges will follow her lead, and whether this moment marks a turning point or remains an isolated act of judicial courage. Subscribe right now if you want to see how this unfolds. This story is developing by the hour, and I'm covering every single development. Hit that subscribe button and the notification bell so you don't miss the compliance hearing, the appeals, or whatever comes next. Here's where things stand right now. Stanley Woodward and Emil Boye remain in U.S. Marshal custody pending tomorrow's compliance hearing at 9:00 a.m. Eastern. Their legal team has 24 hours to produce the ordered documents. If they comply, they'll be released and the criminal contempt charges will be dropped. If they refuse, they face formal prosecution and potential sentences of up to 6 months. According to sources familiar with the situation, Trump's team is currently debating whether to produce the documents. Some advisors reportedly argue that compliance is the only rational choice. Others, aligned more closely with Trump's instincts, are urging continued defiance, viewing the Marshal custody as a political asset rather than a legal catastrophe. The compliance hearing tomorrow will determine the next phase. If the documents are produced, Judge Caldwell will evaluate whether they meet the order's requirements. If they're not produced, she'll formally refer the matter for criminal prosecution. Meanwhile, Trump's campaign has scheduled a press conference for later tonight where they're expected to attack Judge Caldwell further and frame the custody as political persecution. Legal observers will be watching closely to see whether Trump's statements tonight create additional legal exposure either for him or for his attorneys. The appeals process is already beginning. Trump's team filed an emergency motion seeking the attorney's immediate release pending appeal. That motion is currently before the D.C. Circuit, which could rule at any time. Keep a close eye on 3 things: whether the documents are produced by the 9 a.m. deadline, how the appeals court rules on the emergency motion, and whether Trump's statements tonight cross any additional legal lines. Any of those could fundamentally change what happens next. The stakes have never been higher. The precedent has never been clearer. A federal judge just proved that defiance has limits and that marshals will enforce those limits when words aren't enough. What happens in the next 24 hours will determine whether this becomes a turning point or an aberration, whether other judges find the courage to enforce their orders, whether the rule of law still means something in this country. This isn't just another news cycle. This is a test of whether our courts still function. I'll be covering every development, the compliance hearing, the appeals, the response. Subscribe now and hit that notification bell. This story isn't over, not even close. I'll see you in the next one.